Good morning, everyone. My name is Heather Lockenauer, and I'm Senior Counsel in the Exempt Organizations Practice Group at Brown and Streza. And on behalf of my colleague, Paul Schmidt, and myself, I'd like to thank you for attending today's Religious Liberty Update, Part 3, which is Cases Affecting Churches, Religious Ministries, and Schools. So just a couple of administrative items before we get started. We'd like to ask you to take some time to complete the survey, which is linked in the chat, and it will be there following the webinar. So we appreciate your feedback very much. Please note also that this presentation is being recorded. We will make the recording available on demand for 30 days through Zoom for all participants. Finally, this presentation is for educational and informational purposes, and it is not intended to be taken as legal advice. We will be addressing questions throughout the presentation, and if you have any questions, please send them to us through the Q&A feature. And we'll also provide a copy of today's presentation slides for your reference. So if we could go to the first slide, please, the description of Brown and Streza. Great, thank you. Brown and Streza is a law firm. We're located in Irvine, California. We provide legal services in the areas of business and real estate, tax, trusts, and estates, and in the charitable sector. And our presentation today is one of the services that we provide to our nonprofit and religious organizations and schools. And now I'll turn it over to my colleague, Paul Schmidt. Good morning, Paul.
Good morning. Thanks, Heather. And good morning, everybody. Thanks for tuning in. My name's Paul Schmidt. I'll just give a very brief introduction. Some of you, I know I can see who are on here, you know who I am, and I've worked with you before, so welcome. I've been with Brown and Streza for at least 2 years now. And before Brown and Streza, I had a number of legal jobs, but I used to litigate First Amendment religious liberty cases, primarily in federal courts. On behalf of churches, religious schools, and other religious institutions. I had a few other jobs before that. I clerked at a federal court of appeals and litigated at a larger law firm doing kind of corporate work. But my main focus in my career, and especially here at Brown and Streza, is providing for the general counsel type needs for churches, religious institutions, and other nonprofit organizations. So with that background, we're always pleased to kind of give these educational updates to let people know what are the things that you need to be kind of on the lookout for to protect your apostolate or your ministry. Heather?
Thanks, Paul. Next slide. So as Paul said, we are both actually involved in providing general counsel services to religious organizations. And in a similar manner to Paul, I've spent much of my life providing guidance and counsel to religious organizations in one form or another, and particularly with respect to educational religious organizations. So I joined Brown and Streza just this past July. And prior to my time at the firm, I served as the vice president for board and legal services and general counsel at the University of Dallas. In that role, I had the great privilege and pleasure of addressing all sorts of risk management, compliance, and legal affairs needs at the university. And prior to my tenure at UD in my law practice, I was a corporate litigator at a nonprofit religious liberty firm, and then at a larger firm that was kind of a full service shop in San Diego. But before I practiced law, I spent 10 years working in the field of international development, first as a volunteer for the Salesians of St. John Bosco in Papua New Guinea, and then for various nonprofit educational and humanitarian aid organizations, and then the U.S. Agency for International Development. My time in Papua New Guinea, which was known as the land of the unexpected, prepared me well for the practice of law, where we find, I know, lots of unexpected things that happen on a daily basis. And I'm sure many of you have encountered unexpected surprises. Well, I guess that's the same thing, something unexpected and a surprise in your work in various apostolates and organizations. And so we're very happy, as Paul said, to provide you with some information that may be helpful for you today. Next slide, please. So just a quick overview. Today, we thought that we would share some information with you about two timely legal topics. In part one of our presentation, we will provide you with information regarding Title IX. But first, we will lay the foundation for our explanation of Title IX by explaining to you a little bit about the hierarchy of statutory and regulatory authority in U.S. federal law. We thought that would be a good platform for us to start from, especially for those of you who may not be working in educational organizations, and Title IX may be kind of foreign to you. Then we will give you an overview of federal civil rights laws before diving into the nuances of the 2020 and the 2024 Title IX implementing regulations that have been promulgated by the Department of Education. In part two of our presentation, we will explain the Pregnant Workers Fairness Act and the Equal Employment Opportunity Commission's implementing regulations with respect to that act. So the Pregnant Workers Fairness Act is also known as the PWFA, and that is something that we'll be using as shorthand throughout the presentation. Finally, to conclude our presentation, we'll walk through the high points of an important case for religious organizations, a case in which the U.S. Conference of Catholic Bishops, which is also known as the USCCB, the Catholic University of America, and two Catholic dioceses are challenging the implementation of the new EEOC regulations with respect to the Pregnant Workers Fairness Act. Next slide, please. So here we have a slide that demonstrates to you in graphical format the hierarchy of regulatory and statutory authority in our federal system of the United States. So you may remember from your 8th grade civics class that the U.S. Constitution is the supreme law of the land. And we don't have the U.S. Constitution listed here, but if we did, it would be at the top of that kind of ladder on the left side of your screen. Next, we have federal statutes, and federal statutes are enacted by Congress in accordance with the U.S. Constitution. So this may conjure images for those of you who are old enough to think of that skit from Schoolhouse Rock, I'm Just a Bill, which walks through the process by which a bill becomes law. And so here we have on the left at the top of your ladder, Title IX, which is the statute that we will be discussing in a little bit more detail today. Title IX prohibits discrimination on the basis of sex in education programs or activities that receive federal financial assistance. The next step on our rung, if you will, the next step down on our rung is administrative regulations. Administrative regulations are adopted and implemented by federal agencies like the Department of Education, the Department of Health and Human Services, and these agencies are part of the executive branch of government. So for those of you who, again, are hearkening back to your 8th grade civics class, this may be something you remember, it may not be, but we have this system of checks and balances in the federal government, and we have the executive, we have the legislature, and we have the judiciary. Well, these federal agencies that promulgate regulations, they aren't part of Congress. So they're not part of the legislative branch. They're actually part of the executive branch. Congress will pass what's called enabling legislation to create agencies, but these agencies are responsive to the executive. And so you can imagine what that means. And many of you have experienced this firsthand, that every time there's a different executive in power in the White House, the agencies have different they have a different agenda. They have different priorities, and so that's a little bit of something that we're gonna talk about today also. So most of these federal agencies are authorized to promulgate regulations, and they have the same effect or the same force as statutory law. So on that second rung, again, you see 34 CFR Part 106. And the application, you see examples in athletics, in admissions, in employment, and in housing. Depending on the agency, these would be implementing regulations. And you also can refer to the triangle on the right side of your screen, which follows what I'm saying as well. And finally, we have administrative or regulatory guidance, such as a Dear Colleague letter. So the Dear Colleague letter is generally not binding, legally binding, and it's subject to different requirements than for regulatory oversight, but it is something that provides advice from an agency in general. Next slide, please. And Paul, I'll turn it over to you.
Thank you, Heather. So Heather was talking about the constitutional order and specifically the way that the federal government's powers work. But if you think about our system, it's a federal system, and the federal government is one of limited powers. So if you go back to your fundamentals, generally your states are the governments that have vast, vast power. And at least in theory, the federal government is supposed to be much more limited. We call it like enumerated powers, which means unless it's in the Constitution, unless the Constitution says and delegates, gives power to the federal government, it can't do it. Now, that kind of in practice ends up being a legal fiction, but in reality, how it actually works out is the federal government has to have a justification for why it's doing or regulating a particular thing. And so here on this slide, you have a number of federal civil rights laws. Okay. Now, look, if you look at the text in each one of these, so you've got Title IX, which we're going to talk about here in a minute. You've got the Age Discrimination in Employment Act. So you've got the Rehabilitation Act, you've got Title VI, and then you've got Title VII. If you look at the language in most of these statutes, you'll see this line where it says that it's dependent on participation in, or that people can't be excluded from participation in or be denied benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So that receiving federal financial assistance bit is important, because what that's telling you is that the constitutional authority for this particular law is probably the spending clause. So Congress passed these laws. They're using their authority under the spending clause of the Constitution. And really, the way that that's been interpreted by the courts is it's almost like a contract, meaning we can regulate what you do because you're taking our money. And so we have this agreement. If you're going to take our money, you're going to do things our way. Okay, so that was a little bit of a windup to explain the principle that if you take the government's money, you play by the government's rules. And this is particularly important for religious institutions because although many of these laws give you religious exemptions, that's not always the case. And you can't always bend on or depend on the idea that just because you're religious, the law doesn't apply to you. That isn't how it really works, right? So if you look at Title IX, which applies to any institution receiving federal financial assistance, right? That would apply to state actors. So if you think about your big public universities, it applies to them. It would apply to even colleges and universities that are otherwise private, if they're going to take federal money. And we all know through the Department of Education, there's a lot of resources out there that would apply here. Now, think about all the other different ways you can get federal financial assistance. You might take hot lunch money, right, if you are a religious school. So there are all these different hooks where if you participate in the federal government's game, then you're going to be subjected to these laws potentially. Now, some of them have exceptions, others don't. And then, the other thing that is important about this is that it doesn't necessarily apply to getting a direct payment from the federal government. So take Title IX, for example. Many colleges and universities may not take money directly from the federal government, although most do, but they may accept students who take federal loans, student loans. And the courts have held that that is a sufficient hook to get them involved in Title IX. So you'll see some colleges or universities will refuse to take any federal money. Sometimes, like Hillsdale is a very famous example. And they might also refuse to take student loan money if it's federally funded. And another good example of that would be, I think, Christendom College. And that's a good example because they're also a religious institution, so they get the statutory carve out. So anyway, Title IX prevents discrimination on the basis of sex. And so that's going to be in all the programs in those educational institutions. The Age Discrimination Employment Act prohibits discrimination on the basis of age, predictably. The Rehabilitation Act prohibits it on the basis of handicap. Now, the Rehabilitation Act predated the Americans with Disabilities Act, and it actually is a little broader than the ADA in some regards. Then you have Title VI. Now, note, Title VI is part of the Civil Rights Act. There are separate constitutional bases for the Federal Civil Rights Act because of the Reconstruction amendments that were passed after the Civil War, right? But that covers a number of what we're going to call protected classes, right? So far we've had sex, age, handicap. The idea is that these apply to people who fit in these particular classes of people. So here in the Civil Rights Act of 1964, it covers race, color, and national origin. A lot of schools know that you got to have this kind of language in your handbooks or other things, because if you're going to take federal money or benefit from federal assistance, they want to have these in your policies. Okay. And then there's, Title VII, which is your employment discrimination. So that, of course, covers race, color, sex, or national origin. Okay. And I think that one other thing that we'll just mention is that the Civil Rights Act of 1964, so that, kind of enables Title VI and Title VII, that also created the EEOC. And so that is one of the federal regulatory bodies that is very important in this space. And I think we can go to the next slide and back to Heather.
Thanks, Paul. And so what does exclusion look like? Paul walked you through each of these different civil rights federal laws, and what each of these laws protects is a particular class of individuals, as Paul also referenced. And so what does exclusion look like? Well, exclusion is generally considered discrimination. It's some type of that's what excluding someone who is of that class of individuals from the activity. And so there are different types of discrimination. And the federal statutes actually track each other fairly well. So they all contain definitions of discrimination that are very similar, whether it's Title IX on the basis of sex, the Age Discrimination in Employment Act, which is also called the ADEA. And as Paul referenced, that has to do with, it protects people who are over the age of 40. So for all of us who are over the age of 40, we are considered old by some measure by the federal government, and we're protected as a class of individuals. And then under Section 504 of the Rehabilitation Act, for those with disabilities, whatever type of disability that is, and this particularly applies to those of you who are working in religious organizations, who receive federal financial assistance, and who are also otherwise not subject to Title I of the ADA. And so this is an important law for you all to know, to realize that Section 504 actually basically implements the same conditions that the ADA contains. And then Title VI and Title VII also contain these descriptions of discrimination, or these definitions of discrimination that would constitute exclusion of a person who's in a protected class. So what does that look like? What is discrimination? We hear this a lot in today's day and age, right? So a failure to accommodate, disparate treatment, disparate impact, harassment, and retaliation are the 5 types of discrimination that are contained within each one of these federal statutes. And so a failure to accommodate is basically inhibiting in some way, or not making reasonable adjustments to an employee's work environment in order to address a disability, to a student's educational context in order to accommodate a need they may have in the classroom. Those examples of a failure to accommodate. A religious practice, failure to accommodate a religious practice is another notable example, and that has been in the news recently, right? Even with recent jurisprudence where an employer was required to make an accommodation for someone's religious practice, and the interplay between their need to attend services and work the same number of hours as their colleagues. So disparate treatment is considered intentional discrimination. So if you intentionally treat one employee differently than the other, based on a protected characteristic. So if you intentionally treat, if an employer intentionally treats someone who's male differently than someone who's female, or someone who's Caucasian differently than someone who's African American, then this would be a disparate treatment, an intentional discrimination, intentionally treating people differently based on one of these protected classes. Disparate impact is the next type of discrimination. This is unintentional discrimination. So if you have a policy that affects a protected group of people, and there's some type of unintentional or maybe ancillary discrimination that takes place as a result of the policy that's been implemented. So this is again unintentional, but it has what's called a disparate impact on a protected group of people. So this occurs when you have a seemingly neutral employment policy or a practice, and it disproportionately harms individuals who are in a protected class, even if you as an employer didn't intend to do so. Then we have harassment. Harassment is generally a form of discrimination that's based on a person's membership or perceived membership in a protected category, and that includes physical, verbal, or nonverbal conduct that is one of these things that's defined in each statute. So in Title IX, harassment is varied. There are multiple different ways that one may discriminate on the basis of sex due to harassing conduct. The first is called quid pro quo, and that is kind of a this for that, which many of you are probably familiar with. The second is hostile environment. And in the Title IX context, a hostile environment is created when conduct is sufficiently severe, pervasive, and objectively offensive. This is important to note because in the Title IX world, the word in between those three things, those three kind of conditions, if you will, is and, not or. In other federal statutes, it's the word is or. And so there's not this same kind of heightened level of analysis when you're evaluating whether a hostile environment exists. And the third type of harassment, which we're going to get into in just a few minutes when we talk about the 2020 regulations, is those infractions that otherwise would have been considered part of the Violence Against Women's Act. So sexual assault, domestic violence, dating violence, and stalking. And as I said, if you look at the other four statutes that we have here, harassment or the creation of a hostile environment is created when conditions are sufficiently severe or pervasive and offensive. And so you have just a different standard. It's not quite as heightened with respect to the other four civil rights statutes that we have here. And then finally, the last way that one may discriminate against a person in a protected class is through retaliation. Retaliation is an adverse action that's taken against someone for reporting or opposing discrimination. So we often think of retaliation in the context of when someone makes a report of discrimination, if as a result they're treated adversely, if some adverse action is taken against them by you as an employer, by a school, if a student makes a formal complaint, Title IX complaint, and then let's say that somehow the school decides to withhold the student's transcripts because the student made a complaint, that would be considered retaliation, unless there were other circumstances involved. So retaliation can also include intimidating, threatening, coercing, or a harassing behavior against any person in a protected class. So this is where these kinds of definitions of discrimination are really important. And we thought that this kind of chart may be handy to keep at hand, or to keep close by, so that you can reference it when you're looking at the creation of policies in your religious organization, or in particular within your school, if you are a recipient of federal financial assistance and are therefore subject to Title IX. We do have a couple of questions in the chat, and so I'm just going to bring this one up. How this question came from one of our participants. How does the law determine whether a school is discriminating on the basis of sex versus discriminating on the basis of what sports bring in money to the school? And so I think that the question is, can there an analysis be made of whether or not there's equity in athletics, right? Is the school indiscriminately somehow uh, making a distinction between girls and boys sports teams? I think, is that your understanding, Paul? That would be my understanding of the question. So
Yeah, so like, because I think if you think about the way universities often work, right, it's like you have to have the same number of teams, both for men and for women. And so the question is, can you say, well, this team doesn't really bring in enough revenue to make it worth it, so we're not going to, have it, for example.
right. And so to answer that question, there has to be every recipient of federal financial assistance, at least, has to complete an equity and athletics disclosure on an annual basis and provide it to the federal government. So that it's not a one for one. It doesn't mean that if you spend X amount of dollars on the men's baseball team, you have to spend the same amount of dollars on the women's softball team. But there has to be equity overall within the men's and women's athletic programs. And if you have boosters who raise dollars and somehow contribute to one team or another, then that isn't, if it's separate and apart from the school, then that's not considered in the analysis, in the equity and athletics analysis. And so I think that's just something to bear in mind. Hopefully we answered your question. And if there's another question as a follow-up, we're happy to address that at another time or during this webinar. So next slide, please. Okay, so now we're going to do a deep dive into Title IX, and the relevant statutory provisions are listed here. So for those of you who work at a school that receives federal financial assistance, you're likely very familiar with Title IX. And as we've explained, Title IX prohibits discrimination on the basis of sex. Title IX also contains a robust religious exemption, providing religious schools with an opportunity not to implement Title IX or provisions that are contained within the implementing regulations that are promulgated by the Department of Education, to the extent that those provisions are not consistent with the religious tenets of the school. And so here we have the basic code section, of Title IX, and prohibiting discrimination on the basis of sex, and then the religious exemption. And so how does an educational institution demonstrate that it is controlled by a religious organization and therefore is not obligated to implement any tenets or anything that's within the regulations or Title IX itself, for that matter, that are not consistent with the religious tenets of the organization? Well, there are a number of ways that the EEOC has actually listed in order for a religious educational institution to demonstrate that it's controlled by a religious organization. The first is pretty straightforward. If an educational institution is a school or a department of divinity, so if it's a seminary, a school of divinity, that's very straightforward, and the EEOC and the federal government would say, yes, it's controlled by a religious organization. There are lots of schools out there that are not seminaries or divinity schools. So what about everybody else? The second way that a school can do that can demonstrate it's controlled by a religious organization is by showing that its faculty, its students, or other employees, that they have to engage in the religious practices. Religious institutions say, I think we're going to have a statement of faith that we'd like all of our employees to sign. And if that's the case, then definitely that would be something that the school could put forward and say we're controlled by a religious organization. The third way that a religious institution could show that it's controlled by a religious organization is if it's within its governing documents, it contains an explicit statement that it is controlled by a religious organization or some part of a religious organization, or it is committed to the doctrines or practices of a particular religion. And so, how does this work? Well, a lot of Roman Catholic educational institutions don't have a statement of faith for their employees or their students because they welcome students and employees from all different faiths. And so a Catholic institution in that circumstance may say, okay, well, we're going to clearly say that we follow the teachings of the Catholic Church within our governing documents. So within our articles, within our bylaws, within all of our kind of governing policies of the institution, and that would be sufficient to demonstrate that the school is controlled by a religious organization. The next way that a school could do this is if it has a doctrinal statement or a statement of religious practices, along with a statement that members of the institution community, of the educational institutions community, must engage in the religious practices of the tenets of that statement. The next way that a school could do this is to publish an institutional mission that is approved by its governing body. So think of a board of trustees if it's a university, a board of directors if it's a smaller school. Then and the mission says that the governing body of the mission says that the school adheres to the religious tenets of the organization that it is kind of controlled by, if you will. And this mission statement has been approved by that governing body. And then finally, there's kind of a catch-all where the school can provide a whole host of evidence to the Department of Education indicating that it is, in fact, in some way controlled by a religious organization. And so the Office for Civil Rights at the U.S. Department of Education will evaluate all of the materials that a school may provide to it in order to determine whether, in fact, a school is controlled by a religious organization and therefore may choose not to implement portions of the implementing regulations of Title IX or part of Title IX itself. Next slide, please. So here we have a pie chart demonstrating a very important kind of critical aspect of the 2020 implementing regulations for Title IX. So in the interest of time, we're not going to walk through every aspect of the 2020 regs. We just thought we would highlight this aspect, which was one of the most important things that the 2020 regulations did. For the first time in the history of Title IX, the 2029 regs focused on the inclusion of sexual harassment as one aspect of discrimination that was not previously considered discrimination under Title IX. And so you may recall earlier, I went through kind of each of those different categories of discrimination, failure to accommodate, disparate treatment, disparate impact, retaliation, and harassment. But sexual harassment was not included in the regs prior to 2020. And so this is a really important and noteworthy achievement of the 2020 regulations. The 2020 regs included a quid pro quo discrimination or harassment, hostile environment harassment, and then all of those infractions that would be considered part of the former Violence Against Women's Act. The 2020 regs do a number of other things, including providing procedural safeguards for respondents. So most noteworthy was the opportunity to confront one's accusers, and to cross-examine witnesses, to have a live hearing, to be provided with all of the evidence that has been presented against the respondent. So this was in response to the administration at the time. It was during the first President Trump's first administration, and the administration at the time was being responsive to a number of different situations that had taken place at colleges and universities where respondents had alleged or asserted that they hadn't been given fair treatment in a Title IX case. And so that's where this really was a focal point of the Department of Education at the time.
You may remember, sorry to interject, Heather, you may remember, for those tuning in here, this was also right after that very famous case about the Duke lacrosse team, where there were rape allegations and the school came down hard on them, and then all the things that ensued after. There were also some famous cases that got litigated elsewhere. Justice, but then Judge Amy Coney Barrett actually dealt with this in a case that came out of Purdue University. And so if you think about back in the timeline of when this was, Betsy DeVos was the education secretary, and the Trump administration was very much interested in implementing due process because they didn't feel like colleges and universities were providing students with that. And so that's part of it. But another interesting aspect of it, Heather, you were general counsel at the University of Dallas around the time this was coming out. What was that like for colleges and universities having to try to implement or react to these kinds of adaptations to the regulation?
Oh, thanks, Paul, for that question. It was interesting because we had to implement the regulations within 120 days. So they were published in May. We had to implement them by the beginning of August. And one of the aspects of the implementation of these types of policies, or the amendment of these types of policies, if you already have policies that address this, is that you have to consider whatever state law may also be applicable. And I was in Texas, we were in Texas, and the state of Texas has very particular state law requirements regarding policies governing sexual assault, dating violence, domestic violence, and stalking. And so the governing body of any educational institution has to approve any policies that treat these kind of four infractions. And so it was a little bit of a scramble for those of you who work in higher ed. You also are familiar with the shared governance concept. And so there's this idea that you have to really make sure you get buy-in from all the stakeholders at a university or college. So that would include the leadership of the faculty. It would include staff participation, and then the board of trustees and the executive team. And so it is a little bit of a challenge. And for those of you who have had to deal with these kinds of changes to the regulations, it's happening kind of every 4 years now. So you feel a little bit like you're getting whiplash, with every presidential administration. As I said earlier, there are different priorities, and you have to be responsive to them because the Department of Education is going to really have a different direction, most likely, with each administration.
Well, Heather, speaking of whiplash, why don't we talk about the 2024 regulations?
Thanks, Paul. That's a great segue. So could we go to the next slide, please? So just by way of background, during his first week of office in January of 2021, President Biden signed Executive Order 13988. And in that executive order, he stated that it would be his administration's policy to fully enforce laws that prohibit discrimination on the basis of gender identity or sexual orientation. The executive order explained the decision of the Supreme Court in Bostock v. Clayton County. Many of you may remember that. And in that decision, the Supreme Court held that Title VII's prohibition on discrimination because of sex covers discrimination on the basis of gender identity and sexual orientation. And so, with that executive order, President Biden kind of put, his priorities front and center to all of those agencies that are federal agencies and part of the executive branch while he was the president, or well, he has been the president, I should say. And so, with respect to the Title IX, the May 2020 Title IX regulations, the Biden administration further asked its Department of Education to evaluate the regs and to determine how to integrate President Biden's priorities, his stated priorities, into a set of new regulations. And so the Department of Education published a notice of proposed rulemaking, which is the first step in adopting regulatory reform. And the Department of Education did this in July of 2022, and then adopted the final regulations in April of this year for implementation by August 1st of this year. So the Department of Education set as its primary areas of change the scope of sex discrimination. So the scope, the definition of sex would now be expanded to include sex stereotypes, same-sex orientation, and gender dysphoria, as we might call it, or gender identity concerns. Jurisdiction, another primary area of change was the jurisdiction of the school and the policy of any school that implemented a Title IX policy. It would expand the scope of the school's reach, basically. And so this was really an effort to address study abroad programs at colleges and universities where Title IX had previously not been implemented. Now, many schools did implement their Title IX policy in their study abroad programs, but many did not because it wasn't required previously. There are a number of new definitions. So the first one, and probably most important, was what is discrimination on the basis of sex, as I just referenced. That was one of the primary definitional changes within the 2024 regs. Grievance procedures. So there was a new kind of option for schools to implement a single investigator model. So in the 2020 regs, as Paul mentioned, there was great emphasis on the importance of due process, and therefore the importance of a live hearing, the presentation of evidence, an opportunity to review the evidence. Within these new regs in 2024, the grievance procedure, the options changed slightly. So schools were still able to maintain the live hearing component of the complaint process, but they were also given the option of moving to a single investigator model in an effort to streamline that process and to make it move a little bit more quickly. So as you can imagine, there were kind of detractors and people who thought that was very good. And it's been quite an interesting conversation over the last year and a half. Pregnancy protections. The 2024 regs also included additional protections for the accommodation of pregnant students, and then finally new training and reporting requirements. So the reporting requirements actually were much more robust, to the point where every employee would have additional reporting obligations if they were made aware of any type of Title IX infraction. And the universities and colleges and any other schools, secondary or elementary schools that receive federal funding, would also have to publish their anti-discrimination statement in a prominent place in every policy that they have. So this is another aspect of the 2024 regulations. Next slide, please. And so this is just the text of the regulations that were promulgated by the Biden administration in 2024. This is the expansion of the scope of sex discrimination. So discrimination on the basis of sex includes discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. And then 106.31, what would be considered discrimination. This defines what would be considered discrimination on the basis of sex, and whether someone is subject to harm. So a school that adopts a policy that doesn't include someone, a prohibition of discrimination on the basis of gender identity, might be accused of exposing that student to more than de minimis harm. So the regulation actually calls out this example: adopting a policy or engaging in a practice that prevents a person from participating in an education program or activity consistent with the person's gender identity subjects a person to more than de minimis harm on the basis of sex. Next slide, please. But then the current administration also recognizes that the religious exemption of Title IX is still in place. So with respect to religious educational institutions, the department agrees that those two code sections that we just showed to you do not apply to an educational institution that is controlled by a religious organization, to the extent that the provision's application would not be consistent with the religious tenets of such an organization. This is why, for many of you who are our clients, we've repeatedly said how important it is and kind of emphasized how important it is to really make sure that your religious mission is within the governing documents of your organization. And so that is something that you can really kind of rely upon not only to provide clarity and consistency for your own constituents, but also in the event that anything would ever happen that would involve the federal government and a question of your religious identity. Next slide, please.
Yeah, just a quick tag on to what Heather was just saying. This is also one of the reasons why we advise a lot of clients to structure their corporate identity in such a way that they are clearly religious. So, like California, for example, has a religious type of nonprofit corporation, a nonprofit religious corporation, and so that's yet another way to signal to whether it's the state government, local entities, or the federal government that you have that controlled by a religious entity. So as you can imagine, people were upset about the new Title IX regulations. And Heather mentioned that this all came downstream from Bostock. So just very quickly, Bostock was the Supreme Court case that was interpreting not Title IX, but Title VII. And it was actually, it had a companion case called Harris Funeral Homes. The Harris Funeral Homes case involved a funeral home in Pennsylvania that had a longtime employee that began identifying as and presenting as a woman, and had been born as a man and had presented as a man for years and years. Well, it was a family run funeral home, and they had a very strict dress code. They had separate sex segregated bathrooms, and so the employee wanted to be treated as a woman, but was ultimately the employer was not comfortable with that, and so the employee sued, and it went up to the Supreme Court, and a majority of the court joined an opinion by Justice Gorsuch that said that really that was discrimination on the basis of sex, because if the man had dressed the same way and had been a woman, there wouldn't have been any kind of adverse employment action. So that same kind of mentality is basically what the Biden administration then took to justify this change in Title IX. Now, remember, Title IX was passed, right, when? 1972. So it had gone decades and decades without this kind of understanding of preventing this kind of discrimination. This is a big shock. Well, not really a shock, because, as Heather pointed out, the Biden administration had this executive order. Everybody knew this regulation change was going to come. And the Administrative Procedures Act specifies that agencies, when they're going to do regulations, they have to follow a series of steps. So you have this, what they call notice and comment period. Notice means here's what we're going to do. Comment means you all can tell us what you think about that. And so they take all the comments. Religious institutions express their religious liberty concerns, which is probably why the regulation and the department acknowledged the religious exemption. But other people objected too, who didn't necessarily have religious grounds for it. So because there was this long window of notice and comment about the proposed regulation, it allowed the opportunity for plaintiffs' attorneys to basically prepare lawsuits that were filed the exact same day that the regulation was published. Okay, so and this is not unusual to this kind of thing. As Heather said, part of the problem with the ping-ponging back and forth is the litigation just grinds up the gears of the government. Okay, so as a result of all that immediate litigation, there were 5 district courts across the country that issued preliminary injunctions, so enjoining the law. Now, the problem with using the courts as a mechanism to try to stop laws is that courts have fairly limited jurisdiction. There are these cases of, you hear about nationwide injunctions where a federal district court, let's just throw a random one out there, maybe in the Eastern District of Texas, will issue an injunction and they'll strike down the whole law, or at least enjoin it as it applies to the whole country. The Supreme Court has been very skeptical of that, and they say, no, we don't want you doing that anymore. So there's a patchwork now of injunctions where this regulation can't be enforced in particular states based on the federal district that the court happens to be in where the injunction came from. So if you look on the screen, you have your list of states where these injunctions are currently enforced now or in place. Now, there's also an administrative injunction in the 11th Circuit, which covers parts of the Southeast. So in those states, you have an administrative injunction because the federal district court didn't grant the injunction to the litigants there, but on appeal, the Court of Appeals stepped in and issued one. And then there's yet another twist to it. So one of the cases, Kansas versus the Department of Education, was brought by several associations, particularly Young America's Foundation, which is kind of a conservative think tank group, Female Athletes United, and Moms for Liberty. You might have heard about Moms for Liberty. They've been in the news for opposing a lot of the gender identity issues over the last year or two. So they came in and all sued. They're all associations, right? So part of a constitutional limitation on courts' jurisdictions is you have to have standing to bring it. Well, these associations bring these claims on behalf of all their members. So it's all the parents who have students in these schools. So that injunction actually applies nationwide to the schools where these organizations have parents who are members. And that is actually being litigated right now because we're not sure as litigators how if that's technically correct. So that's a side litigation issue. So it's basically, it has created this patchwork. It's kind of a mess. And then all this goes up to the Supreme Court. And in October, the Supreme Court said, yeah, we're going to leave the injunctions in place. What does that mean? It means that the Supreme Court probably thinks that these regulations are maybe in violation of the statutory authority that they've got. And does it matter anyway? I don't know, because if we go to the next slide, what is going to happen here? You have the election of Donald Trump. Now, you may remember, we are a law firm. We don't have any expertise in politics, but I was reading an article the other day that was talking about exit polling, and they said that one of the most effective advertisements that the Trump campaign used in swing states was on the gender identity issue. And you might remember, if you saw it, it was the tagline was something to the effect of "He's for you, she's for they, them." Okay, so he campaigned aggressively against the gender portions of the Biden-Harris administration's policies, particularly involving Title IX and women's sports, but other policies too. So he also said in an interview on a Philadelphia talk radio show, we're going to end it on day one. And he said, don't forget what was done as an order from the president came down as an executive order, and we're going to change it. On day one, it's going to be changed. Okay, that's his quote. So what does that mean? That means that when a presidential election happens, yes, you get the president. But as I like to call it, you also get all the king's horses and all the king's men. The people who make up the federal government, whether it's the cabinet secretaries or the political appointees, and there's thousands of them across the federal agencies, including their lawyers, are going to get in there and start to change all these regulations. Sometimes the regulation will just be outright repealed. We expect that these Title IX regulations, at least in part, are going to be repealed. Now, the thing is that can take some time because of, again, the Administrative Procedures Act and everything else. There also can be resistance within the agency from career people who are in the career service. So you're good, but the takeaway is they're going to get rid of the regulation. I just want to mention, and we got to wrap up here, but there are also other ways that the Trump administration could undermine these regulations because all these other lawsuits are going on right now. One of the things that the Department of Justice and these agencies can do is they can actually settle the litigation on terms that are favorable to the plaintiffs. So they might maintain their litigation posture as implementing these regulations, but then settle them in a way that they stipulate that they overstep their bounds or whatever, and then that kind of has precedential value going forward against a future administration in the government. And they can also switch litigation positions. They can decline to enforce the regulation altogether. And those are all tools in their toolbox. So come January, you shouldn't expect to see these new regulations being aggressively enforced. And then I think maybe we can, Heather, we've got probably 6 minutes left. Should we open up to questions or kind of just give a broad introduction to the Pregnant Workers Fairness Act?
Let's just give a broad introduction, and for those who are on the line, hopefully we can provide you with a more robust explanation the next time we all come together. So, Paul, I think it might be advisable for us to give a little bit more devotion to this topic on another webinar.
I
You,
think, right.
yeah, you all have the slides that we prepared, but let's just give an overview of what it is and then what the EEOC did, basically.
Okay, so I'll just give a very high level thing and kick it over to Heather. So this act was passed in 2022, as you know. So there were parts of federal legislation that didn't really deal with pregnancy and childbearing, and so was Congress was really trying to address things that weren't covered by the ADA, they weren't covered by the Disability Act, and you're starting to see some pretty broad bipartisan support on trying to support childbearing and enable people to carry on with their careers. So it applies to any private employer with 15 or more employees. So super small businesses, not so much. But if you have 15 or more, then it's going to apply to you as a small business, and also it applies to government employees. It looks a lot like the Americans with Disabilities Act, except it's for those who are pregnant. And so if oh, go ahead, Heather.
No, I was just going to say, if we can stay there for a minute, I would just add that that it makes it illegal for employers to deny a pregnant woman reasonable accommodations. And so to the point that Paul just made about the rubric that's embedded within this statute, it's really adopted from the Americans with Disabilities Act. So an employer has to provide paid time off, has to provide bathroom breaks, potentially modified work schedules to women who have physical limitations that are brought on by pregnancy or by childbirth. And so those are kind of the basic tenets of the act. And the legislature agreed that this was something that was sorely needed. There were just too many gaps in federal law that didn't provide adequate protection for pregnant women. And across the board, as Paul said, there was bipartisan support for medical conditions that are related to pregnancy. And so this really was all about providing pregnant women and those who had just given birth with the necessary accommodations that they should have in order to be able to continue to work. The Congress provided the EEOC with an opportunity to create implementing regulations. And so the EEOC was tasked with this project, if you will, by Congress, and it was meant to be something that the EEOC would take into account, looking at the legislative history of the act. So throughout the discussion about this Pregnant Workers Fairness Act, as I said, there was bipartisan support for pregnancy. Nowhere was the termination of pregnancy mentioned. And the U.S. Conference of Catholic Bishops, which we referred to earlier, the USCCB, was a huge proponent of the passage of this act for the reason that it was promoting the dignity of women. It was supporting women. It was supporting families. It was filling a gap in federal law that needed to be filled. Well, the EEOC decided to expand the scope and the definition of what might be considered a medical condition or a medical procedure that is similar to somehow defined by pregnancy. And the EEOC implementing regulations included provisions for accommodations related to the termination of a pregnancy. Immediately, the USCCB, two Catholic dioceses, and the Catholic University of America sued the EEOC and said, hey, this is not what the act contemplates. you've violated a number of different things, including the Administrative Procedures Act that Paul just referenced, the Major Doctrines Act, the Religious Freedom Restoration Act, and various violations of the First Amendment. And they requested a preliminary injunction while the case was pending in federal court in Louisiana, and the court granted the injunction. The court found that if the legislature, the Congress of the United States of America, had intended to include termination of pregnancy as an accommodation within the PWFA, then it would have said so, particularly in light of the fact that we're in such a kind of a cultural moment right now where the discussion surrounding the termination of pregnancy and states after following the Dobbs case and states' interest in regulating that type of procedure and providing for accommodations for certain things in state law we're at such a moment where all of that is in the culture, it's in society, it's in legislative discussions. And so if Congress had intended for that to be part of this act, it would have said so. So Paul, any final thoughts on that?
No, I think that's a good primer, and we can return to it in a future webinar. And also, we had a couple people submit questions ahead of this webinar related to religious liberty topics that you're interested in. Go ahead and reach out to us. If there's something that you want addressed in a future webinar, we're glad to do it. Also, if you reached out with a very, what I'll call particular question, we will email you individually with a quick answer if we can do it, or we'd be also glad to offer a complimentary 30-minute consultation. And you're going to see in the chat some of the details on how to get one of those. Heather?
Thanks very much, everyone. We really had a wonderful time talking with you today, and we hope that you'll join us the next time. Have a great day.
Thank you, and God bless.